Okay, life before Proffers. Some of you may remember these, bucolic days where the dairy cows roamed in the streets of Tyson's Corner, and life was good. But in Springfield, I remember meeting an attorney, an older attorney who had, was in his 70s at the time. This is some years ago. He said, "I'm a local dirt lawyer from Springfield," and he said it just like that. I'm like, really? How long ago was that? In any event, so there is sort of a bucolic, sort of a forecast Proffers life. And I want to talk a little bit about sort of where we evolved and why we have conditional zoning at all. Before we talk about how we ought to change it or should we change it, it's important to know why did it develop, where did it come from. And really, those of you who've heard the topic, you all know that zoning evolved from the law of nuisance. The idea that the government should protect people from nuisances that are public welfare. And governments have always had the authority to halt public nuisances, even on private property, if it affected the community's best interests, under what we call the traditional police powers. Before zoning, even before the word zoning was actually ever used, there were a lot of laws on the books that affected the public interest. Things like height regulations, nuisance uses like pigs can't be kept in the middle of town. Things in Colonial Williamsburg, for example, having setback requirements. As our industrial society grew, things like height requirements became more and more important. Things like that. Even in the early days of Jamestown, we had requirements saying that the wells had to be a certain distance from the sort of more industrial uses of Jamestown. So laws have always evolved to deal with those types of uses. And here's the authority. There was a question about, you always hear at public hearings, what right does the government have to tell me what to do with my private property? Y'all hear that at public hearing? I've never heard it. But anyway, as early as 1887, the Supreme Court said, government has that right. And here it is. Zoning as we know it today developed in the early 20th century in sort of response to the industrialization and some of the real harms, if you will, and public health issues, safety issues associated with sort of more urban living. The first zoning ordinance was developed in 1916 in New York City. Go figure. And there were model zoning ordinance and modern zoning enabling acts that developed. Good old Herbert Hoover was the Secretary of Commerce at the time. He was a big proponent of that. Back when Republicans had progressives in the party, he was a Republican progressive. Almost immediately, people saying, "What is government doing? Telling me what to do on my private property," attacked it as a taking. They said, "You can't zone my property. Tell me what I can and can't do. You've taken my property." Well, Supreme Court said, no, it's not a taking unless it goes too far. The Virginia Supreme Court followed suit in a case involving the city of Roanoke zoning ordinance, and really affirmed that legislature may, in the exercise of the police power, restrict personal and property rights in the interest of public health, public safety, and for the promotion of the general welfare. That's the bedrock of zoning. But here are some issues about zoning. One of the advantages of zoning is the uniformity. You can prescribe what uses can and can't be done, and they have to be done in a certain manner. But what if that doesn't make sense? What if you need to make an exception? What if it doesn't actually apply? Well, there are certain sort of fail-safes. There's the constitutional fail-safe of the variance that you can get from the Board of Zoning Appeals. If you can prove something is a taking or approaching a taking, you can actually get a variance from the Board of Zoning Appeals. But it's very difficult to get one of those. The Cochran case was decided a few years ago, reaffirmed the fact that it was difficult to get a variance under the legal standard. There are also special exceptions that you can get, not just through the legislative process, but if authorized by ordinance, the zoning administrator can actually grant certain limited exceptions. But there's a limited ability to vary the zoning and to address certain things. And even then, you're essentially waiving or varying certain things and not everything else. What if there is a certain proposed use or proposed zoning and you had this additional impact that was not otherwise already addressed in the ordinance? Well, if you're applying for a special use permit through a legislative process, the government has the ability to impose conditions. We all know that, and that's great. They have to be reasonable, etc., and they have to comply with the statute, but you can do it. But through zoning, you can't impose conditions in zoning. Zoning is zoning. Well, how do you deal with that? The concern was you're dealing with a uniform zoning ordinance, and it applies to your property once it affixes. And so there were issues. Localities were able to deny the rezonings when requested because it simply had too many impacts on, again, the health, safety, welfare of the citizens. And folks that were applying for it didn't really like being denied their zoning applications. And there were many cases when the local governments didn't want to deny it either, but they kind of felt compelled to because of the impacts of that particular development. But developers and applicants for rezonings would come in and say, well, but wait, I understand there's going to be impact on the school system. I understand there's a safety issue for that bridge or something. And I understand you want a sidewalk. I understand you want these things. But you know what? I'm willing to do them for you. But then clever local government attorneys like me said, no, you can't do that. That's illegal, okay? And sure enough, the Supreme Court agreed and said, no, you can't do that. And so folks started putting their heads together, and folks that are much smarter than me went to the General Assembly and thought up a new way to handle it. And like I said, contract zoning, conditional zoning, illegal in Virginia. So what to do? As Mike said earlier, Virginia came up with its own unique solution. We're unique. We've got Jamestown. Nobody else has Jamestown. We've got certain unique things about Virginia that's true nowhere else. Hokies and Cavaliers and things like that. But one of the things that's unique about us is our conditional zoning system. And this was actually, and of course I think Mike will probably correct me if I'm wrong, but the fact is, conditional zoning was developed in response to some of the folks in Northern Virginia who were getting turned down. In Fairfax County particularly, Fairfax kept on turning them down. And they said, well, but we really want to find a way. And local governments, like I said, often wanted to find a way to approve some of these things as well. They just wanted a legal mechanism to enforce the kind of promises that were made at the podium. Now, your local government attorney will advise you better on this, but believe it or not, when somebody stands at the podium in a zoning application says, I promise, I'm going to take care of that issue, we're going to address it, don't worry about it. Not enforceable, okay? Not enforceable at all. It needs to be in the proffers, it needs to be something that's actually in writing and is legally enforceable. So, greater minds than me came up with conditional zoning and proffers. It was first authorized, conditional zoning, in the mid-70s for counties with the Urban County Executive Forum, Fairfax. Yeah. Isn't that great? That's another unique thing about Virginia. We authorize these general legislative approvals that are only applicable to one locality. Anyway, and apparently at the time it went to the General Assembly, there was a key vote on a key committee that happened to represent the Eastern Shore, so Eastern Shore got it too. Isn't that great? I think it was years before they realized they had it, but there you go. In 1978, in response to concerns from the higher growth communities outside of Northern Virginia, they said, but wait, we want that authority too. Well, there was concern about the breadth of the original approval, and so there was given a more restricted version of conditional zoning authority to so-called high growth communities, or ones that met certain growth and size thresholds. I'm sorry, I skipped ahead. 1978, the new conditional zoning was a severely limited version of conditional zoning. And then in 1989, the high growth communities got their sort of hybrid version of the two. What is conditional zoning? Well, if you read it directly out of statute, it is, if authorized in the local zoning ordinance, it's the voluntary proffering by the owner of reasonable conditions in writing prior to the governing body's public hearing, or later. There have been recent statutory changes to allow it later, so much so that it's kind of unclear as to when you finally have to submit those things. In addition to the general zoning regulations, that's important. In addition, you can't vary the existing zoning regulations. It's additional zoning regulations. As part of a rezoning, or some kind of a zoning map amendment, sometimes it's called a zoning map amendment instead of a rezoning, but that's what I mean. Again, there are three types of conditional zoning. I'll go into a little more detail now. the new old, which is the high growth stuff. One significant thing is in 2005, as part of the Governor Kane transportation, linking land use to, et cetera, thing that happened in 2005, authorities that are high growth could, by ordinance, adopt the old Northern Virginia style proffers. And so if you represent one of those localities and you wish to have more flexible conditional zoning authority, say so in your ordinance, and then you can exercise that same breadth of authority in Northern Virginia. And then, of course, everybody else is governed by the new conditional zoning. The old conditional zoning is very flexible. It's very broad in scope. It basically is relatively unlimited, except that it has to be reasonable. Well, that's interesting. What's reasonable? I guess the legislature gets to decide those things, right? Until a court decides instead. The constitutional requirements of nexus and reasonableness that were in the Nolan and Dolan cases from a few years ago. In other words, it has to be actually related to the zoning itself in some manner. It can't be something that's completely unrelated. Those types of things. And there's apparently one or two constraints. One of them is that you can't have property owner association facilities funded through it, and that's actually runs through all of the three. The new conditional zoning says yes, you can do it, but here's a whole lot of things you can't do. Okay, it's a fairly limited authority, but it's helpful, when in situations on site in direct ways that impact the development of the site. It's not a bad way to go. But rezoning has to give rise to the conditions, has to be a reasonable relation to the rezoning. You can't do any cash, no cash at all allowed under this form of conditional zoning. You can't have any dedication of real or personal property. Again, you can't have those property owner association improvements paid for by generally. You can't have off-site improvements, which is severely limits some of the types of things that you might normally see in conditional zoning. It must be related to physical operation or development of the site. That's again a severe limitation. And it has to conform to the comprehensive plan. New old conditional zoning. This is the high growth community proffer authority that was put in 1989. In this, it has some restrictions, but not as many as the rest of the state. It's not as flexible as in Northern Virginia, but it is much more flexible. Rezoning still must give rise to the conditions. Has to have a reasonable relation to the zoning. That seems to make sense. Again, no property association improvements and paid for by these fees, except in a few cases. Has no off-site improvements, but it has an exception unless it's in the CRP or it's not typically included there. So there is a little bit of flexibility there. It has to have the capital improvement plan, and it must conform to the comprehensive plan. Significant changes from the new sort of statewide conditional zoning authority include the restrictions on no cash proffers is gone. The restriction on no dedication of real or personal property is gone. The restriction on that has to be related to the physical site development or operation is gone. So that freed up these communities to do a little more a few more things that are flexible. Over the years since those were put into place, there's been a number of amendments over the years in reaction to perceived or real concerns in one or more communities. The General Assembly has sort of tinkered with the authority over the years and have said, well, you can't do this, local governments, or you have to do it in this certain way, or you have to report to us the things that you're doing with it. You have to use the cash, for example, in a certain way. And so there have been a number of amendments over the years. A couple of them are vesting in reaction to some downzoning that occurred in actually late 1989 in Fairfax, in 1990 and I believe 1991. There were some vesting provisions that went into effect that said under certain circumstances there will be vesting if there are proffers that are done a certain way. The first one is codified in all three forms of conditional zoning as subsection B. It says if proffer conditions require dedication of real property of substantial value or construction of substantial public improvements, the need for which is not generated solely by the rezoning itself, then essentially you can't downzone the property. That's essentially what that says. Unless you've got, the usual exceptions to vesting, mistake, fraud, mistake, blah, 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 which we rarely, if ever, see. So the bottom line is, if you meet this, then they are vested. A similar type of provision under subsection C in each of the three forms basically provides that if there are, before July 1st, 1990, proffer dedication of real property of substantial value, which is not generated solely by the rezoning, essentially you have to advise, and then you need to diligently pursue it thereafter. That's been long enough ago now that you do not see that very often now. In 2001, the General Assembly was concerned that there were abuses or reported abuses or alleged abuses or real abuses, we're not sure which. When you're down at the General Assembly, it flies fast and furious, okay? But in 2001, they addressed the concerns about use and reporting of cash proffers. One of the concerns was it's being used inappropriately. The other was nobody knows what they're doing, make them tell you. So this statutory amendment required inclusion of cash proffer money into the CIP, and it had to be expended within set time frames. 7 years is what it has been. The new bill provides for 12. Thank you, General Assembly, for the added flexibility. We appreciate it. Also provides some flexibility to the locality in what improvements they can spend it. For example, if it's been proffered for a certain use, but you can't use it because you don't need to do that anymore, if you've amended your CIP or whatever to rule it out, you can still use it for other things in the area. So this is a very good and helpful thing that came out of this. And there also was a requirement for the localities to report to the Commission on Local Government. That's what COLG stands for, Commission on Local Government. You run out of space on these slides, So COLG is Commission on Local Government. There's a requirement for reporting about how the cash proffers are received and how they're expended. In 2005, the General Assembly was concerned on the actual substance of the proffer, what it could contain. Again, there were alleged abuses, perceived abuses, real abuses, all of the above. And the General Assembly said you cannot mandate a cash proffer be paid before the building permit stage unless the profferor voluntarily agrees, and it's Northern Virginia or a high growth community. Now, between you and me, proffers are always voluntary, right? So I've always been a little unclear as to what this meant, but I know Mike probably knew what it meant when he suggested the language. Proffers cannot escalate annually faster than the Consumer Price Index, and they actually identify which Consumer Price Index because there's a lot of them. So it essentially provides an escalator clause. I think some localities are escalating faster than the General Assembly thought that they should. And then in 2012, there was a related one that said proffers cannot waive future rights vis-a-vis the locality, and any such proffer is void. There were certain communities that were embedding or suggesting and accepting proffers that had embedded in them certain things that would sort of reduce the landowner's right to come back at some future date to change things and affect things. And so the General Assembly said, no, that's not right, so we're going to make sure that they can't do that. In 2010, the payment of the cash proffer, which had traditionally in most localities been at the building permit stage or site plan approval stage or some other stage, was moved back to the certificate of occupancy stage. And the argument behind that, as I understand it, was we're in a tough economy. There's this sort of float between the time that the builder has to take out the loan and actually starts building it, i.e. you get a building permit, and then the date that they actually close on the property when the homeowner actually writes the check, has the closing, buys it, and they can pay back the original loan. And basically, that additional cash proffer was built into the construction loan for the builder, and they tried to take that float out. In any event, one of the interesting issues is that the statute itself in 2010 did not say anything about whether it was retroactive. And so there were a lot of local government discussion by local government attorneys as to how should that be dealt with. We all know that conditional zoning and proffers are a legislative enactment. Once they're accepted, there are actually additional regulations added to the zoning ordinance. And so there was a number of local government attorneys that believed that you can't do that without undoing the legislative process that created it. And that seemed to make a lot of sense. And then there's a whole other body of case law out there that says when the General Assembly wants something to be retroactive, they say so expressly. And there's nothing in this that says it's retroactive. Now, there's certainly words that I know folks have argued mean it's retroactive, but there's actually no statement of that to the effect in here, whereas the General Assembly in other statutes has expressly stated retroactivity in other cases. As a result of that, some local governments took the position that it was not retroactive. In other words, for proffers accepted after the effective date of this amendment, we would honor this requirement about delaying the receipt. But otherwise, for previous proffers that had already been accepted, we will continue accepting them at the time of the building permit. In fact, there were reported cases where a local government may have said, well, but wait, we don't really want your cash until later. And they said, but wait, the bank's making me give it to you earlier, okay? Because they say that there's this condition that I've all complied with and their loan's in default, and we got a real problem with that. So there were a lot of issues like that. Well, the Attorney General decided he was going to take that bull by the horns and opine that it was retroactive. And I read the opinion, I disagree with it. It is what it is. I respect the Attorney General's office. I don't respect this opinion because I think it is inconsistent with the Virginia Supreme Court's precedent on retroactivity. Now, he's one lawyer, I'm another lawyer. We can disagree, that's what lawyers do. But interestingly enough, James City County decided to take the bull by the horns and not to leave it out there for, we're not sure what the law is. They actually found a few sympathetic builders to come in and participate in this, and they had a declaratory judgment action filed in James City County Circuit Court to decide the issue as to whether it's retroactive. The Home Builders Association intervened in that case and litigated and actually prevailed. The Circuit Court judge in James City County agreed with the home builders and said it was retroactive and that James City County had acted inappropriately in not honoring retroactively as well as prospectively the intent of the 2010 amendment. James City County has appealed that to the Virginia Supreme Court just a couple of weeks ago. Well, it was a few weeks ago now. We heard that typically there's a two-step process to have a case heard by the Virginia Supreme Court. You have to apply for a writ of certiorari. You have to ask permission from the court to be heard. And then once you get permission, then you brief it to the full court, you argue, etc. And most applications for appeals are not granted. Most writs are not granted that are requested. So you have to go down and you have to make an oral argument to a writ panel at the Virginia Supreme Court explaining why your case should be heard. In this case, the Virginia Supreme Court waived that argument and said, we don't need to hear from you, you got your writ, come down, we want to hear from you. Now, does that mean that they're going to reverse it? More certainly, I don't know. But it certainly means they're very interested in this issue. Very interested in this issue. I think it's a fair statement. So we will get a decision on this point in sometime in the coming year. It'll be briefed in the coming months, and it will be heard when it gets around on the docket at the Virginia Supreme Court. So we'll be watching this very carefully to find out what the rule is on the retroactivity of this statute. In addition to that, there's some other judicial challenges that I think are important to be aware of and discuss with your counsel when you're working in the conditional zoning area. One is National Association of Home Builders versus Chesterfield County. They attacked the cash proffer policy essentially as a taking, and they were told by the Eastern District of Virginia Federal Court, no, it's not a taking because the rough proportionality of Nolan and Dolan are met. In other words, we're going to treat this like any other legislative zoning enactment, and as long as you have a rough proportionality, it's not a constitutional issue. Go talk to the local General Assembly and change the statute if you don't like it, which they did. One of the significant things about this case is it really deferred to the local government and confirmed that this was in fact a legislative enactment that gets the same kind of deference as every other kind of zoning enactment at the local level. Board of Supervisors of Powhatan County versus Reed's Landing. This was one of the first cash proffer cases that actually involved an applicant, developer, home builder who basically came in and wanted to do a very large subdivision in Powhatan. There was a cash proffer policy in Powhatan that suggested a certain dollar level. The developer applicant said, no, I'm not paying it. And so, tough, I want you to approve me anyway. One of the supervisors was quoted, and this went into the evidence of the circuit court, that, well, you haven't given us the cash we asked for, so we're going to turn you down. Or words to that effect. Which, if those of you are taking notes on how not to handle a cash proffer case, that may not be the best way. Okay? Well, in any event, it went up, and it was decided, and of course, the Supreme Court ultimately decided on the record that came from the Powhatan Circuit Court, which was very poor for the local government. There really was no evidence of any other reason that it was turned down, and it was really just that. And it really turned on more of a Dillon rule issue, which is, again, proffers are supposed to be voluntarily submitted, right? And so in this case, they were basically told, you proffer the cash or else. And so therefore it wasn't voluntary, therefore you don't have the authority to accept that proffer because it's not voluntary. That was the reasoning of the court. Now, Gregory versus, now you look at the dates here, 1995, and then 4 years later, we show up with Gregory versus Board of Supervisors of Chesterfield County. Nearly identical facts. You got a home builder wants to build a big subdivision out in the rural area. There's a lot of concern about it, people coming out of the woodwork to oppose it, and what do we do about it? Well, again, the developer-builder applicant said, I'm not proffering the cash in your cash proffer policy, Chesterfield County, and you can't make me. Look at Reed's Landing. Has to be voluntary. I'm refusing to do it. If you say that I have to, it's not authorized under the statute, and you lose, say the developer applicant. Well, the boys in Chesterfield County, and fine ladies too, did a very good job defending that case, because in addition to the lack of the cash proffer, they actually brought into evidence in the Chesterfield County Circuit Court a number of other reasons why it also got turned down, like impacts on the health, safety, welfare of the citizens, transportation impacts, school impacts, other things like that. And so upon that entire record, the Chesterfield, ultimately Virginia Supreme Court held that's adequate and that's sufficient. And so despite the fact that the general situation and facts of both cases seem very similar on their face, the actual proof and the record that came from the circuit court to the Supreme Court was fundamentally different. And so that's one of the sort of practice points, those of you that are in these cases, as you get confronted in litigation involving cash proffers and other things like that, make sure that you establish an effective record at the circuit court level, so that when you go to the Supreme Court, then you've got an argument that's better than the one that the poor folks in the Reed's Landing case had. And again, they confirmed that Reed's Landing really was a Dillon rule type of decision. In that case, under those facts, it was an involuntary proffer. But in this case, it's not an involuntary proffer because it was denied for a plethora of reasonable, reasons, etc. Cash proffer policies. I've talked to a couple of times about cash proffer policies, and my friend from Loudoun County is going to be addressing how Loudoun has addressed this in a significant detail, so I'm not going to spend a lot of time on it. But Chesterfield County was one of the first localities to adopt a cash proffer policy. I don't know, Charles, if you were before Chesterfield or after Chesterfield, but about in that same time frame, I suspect. Many other localities followed. Many just used the methodology in Chesterfield. Others tweaked it over the years. Common policy content includes a per unit maximum cash proffer from the CIP for the categories covered, like schools, transportation, libraries, public safety, etc. Typically, it's residential only. The thinking is that residential usually doesn't pay its way for public improvements, whereas commercial and other types generally do. I will tell you that that may or may not hold water depending upon what type of residential development and what type of commercial development you're talking about, but that's generally a true statement. Most cash proffer policies have adjustments for other things. In other words, there's a maximum cash proffer of a certain amount, but if you're giving us a school site or you're restricting the age limit to 55 and so we don't have many school kids, or there's other types of things in there, then we can take that into account and adjust our cash proffer. As a matter of fact, that was one of the things in the Gregory versus Chesterfield case that the court cited to say this is a reasonable cash proffer policy. It was not a involuntary cash proffer. And typically, the cash proffer policy is revised every year when the CIP changes. So when the capital improvements program is revised and it has different things in there, then it's revised, and that dollar amount is sometimes adjusted, sometimes not. Recently, given the economy, there's been a lot of political pressure on local governments to revisit their cash proffer policies. The argument, as I understand it, is that it is somehow restricting growth and development in the residential sector, and that the cash proffer amount is somehow preventing the economy from recovering and preventing the creation of jobs. Whether you agree with that or not, some localities have, in fact, reacted to that argument and have, in fact, changed their cash proffer policy significantly. Hanover, for example, in 2012, completely eliminated the cash proffer. It just completely said, we don't want any more cash proffers, and not do it at all. I will tell you that there are communities that don't do cash proffers. Henrico has never done a cash proffer, which is adjacent to Hanover. And I don't know if Henrico's had any greater success in having homes built there in the down economy than Hanover, but that's something I don't know and have not investigated. But in 2013, Hanover decided to reinstate a portion of the cash proffer, reinstating it for roads only, and their current cash proffer amount, as I understand it, is $23.06 from newspaper reports that I've read. Last week, Chesterfield County completed its reconsideration process. They appointed a whole group that was investigating what to do and how to do it, and had representatives from various people. And they, in the end, made a recommendation, and ultimately the Board of Supervisors in Chesterfield last week decided not to change their cash proffer at all. And so it is still at the 18,966 unit thing. Yes, sir?
Is that for a single home on a separate lot, or is that per unit, including attached homes, duplexes?
That is a single-family residential unit, and that's from a newspaper report. There may be a lower limit for something else.
It's not.
It's not. It's the same for everything?
Doesn't matter what type of unit.
Brennan is the voice of reason. Impact fees. Talking about impact fees real briefly, just because I know that is a topic of interest in folks. Whenever anybody talks about doing away with cash proffers down in the General Assembly, a lot of folks, including local governments, are like, well, okay, but we're relying upon some of this money for what we're doing. What's going to replace it? And one of the things that is discussed is, well, impact fees. Impact fees are used in other states. As a matter of fact, I said we're unique in our cash proffer conditional zoning thing. Impact fees, we'd be joining a fairly significant group of states that do it that way. And so it's certainly something I think worthy of consideration. It's arguably fairer because it applies more broadly than just people coming in for rezonings. It applies to every new home that's being created. It's typically collected as subdivision. Sometimes it's collected to building a permit. And other states use it to address the cost of growth, and it's certainly more common. But I will tell you, my experience as county attorney in a couple places, it's potentially more volatile. And in discussions with my supervisors over the years on the various impact fee proposals, the concern has been, well, it's one thing to say that folks coming in and building new subdivisions, and they're basically taking ag land or green space, and they're churning it into this much greater dollar value per unit, can absorb this a whole lot more easily than mom and pop on their dream acres. They bought the lot and they want to build a home on it. For them to absorb $18,000 in Chesterfield is asking a lot, okay? And so there's been some pushback, not just from the home builders, but from the local governments themselves against impact fees. And certainly, there's certainly a strong argument that it does impact the bottom line price of the unit, just as cash proffers do. The argument being that if there's no exception, as many policies do for affordable housing, etc., then that would affect affordable housing as well. Perhaps as a result of that, and the yin and the yang, and both local governments and home builders saying we don't want it, they're generally not authorized, except in a few cases. In 2007, impact fees were authorized for urban counties with urban transportation districts in which the county maintains its own roads. There were certain restrictions on that. It had a limited applicability. Mike Tolson reminded me earlier that it actually had a sunset clause, and so unless you happen to be one of these communities that has their own roads and adopted it back in 2008, you're out of luck. This is now off the books for you unless the General Assembly, like the next statute, decides to remove the sunset, which could happen. In 1989, road impact fees were authorized for localities with a certain size of population and a growth rate. It was set to sunset in 2003 if no locality adopted it. there were fundamental promises made to the General Assembly by at least Stafford County. We will do this if you authorize it. And in fact, Stafford did do that. They met the requirement, and then the General Assembly subsequently removed the sunset because Stafford had done what they promised that they would do. This impact fee is allowed for road improvements only, so it doesn't go to schools or parks or public safety or any of the other things that cash proffers deal with. It requires a lot of complex steps, and you've got to read the whole series of statutes. There's 10 or 11 different statutes that impact this, that implement this. You got to have an ordinance, you got to have an advisory committee, you got to have a impact fee service area, you got to have a road improvements program. There's rules for how it gets collected. There's a formula how you determine it. There's a requirement for credits. You have to update it on a regular basis, and then there's a restriction on it that has to be refunded if it's not used within a certain period of time. So Stafford has adopted it. In fact, they recently expanded it countywide. Previously, it had just been certain impact fee districts, and they recently expanded that to countywide. So Stafford's now doing the road impact fee on a countywide basis. And so if you're interested in this and you meet that restriction, you might talk to Stafford how it's working for them. And I just said that they did that. One of the things I thought about as Mike was asking me to do this overview is that, well, if cash proffers are imperfect, need to be reformed or removed, question, would a more flexible, broadly based impact fee be a good replacement? Maybe, maybe not. Maybe it would be politically difficult. Maybe it simply wouldn't be a good idea. But it certainly is something that's discussed frequently, in fact, pretty much every year down there. Impact fees really could not replace conditional zoning there, because you remember back at the very beginning of my presentation, I talked about conditional zoning being a reaction to the restrictions of a uniform zoning ordinance, right? Cash is only one piece of conditional zoning. It addresses a whole lot of other things. And so I guess one of my, sort of, again, putting on my thinking cap about what should be done here, one of the things that I think the General Assembly needs to think very seriously about is if you are going to do away with a cash proffer or adjust it in some way, don't throw the baby out with the bathwater. Conditional zoning has actually been a very flexible, very effective way to address problems with certain developments that could be, in fact, proffered through reasonable voluntary conditions. And so instead of just throwing it out, perhaps adjusting it in some way makes better sense. Again, conditional zoning was intended to address a whole lot of issues, not just cash. In conclusion, conditional zoning has operated, reasonably well. We're at a 40-year anniversary. I guess Mike said earlier today that's a good long ripe age for any program in Virginia. And it does allow site-specific and improvement-specific things. There are reasonable restrictions on it that have been imposed over the years to address concerns that have been raised. But it works, reasonably well. Concerns related to cash proffers, have resulted in those statutory amendments. Certainly the General Assembly has got a very keen eye on this sort of thing, and as concerns have been raised, and will in the future, I'm sure we'll see other statutory amendments that affect this. And of course, as I just said, impact fees are authorized only in very specific examples and only really on a limited basis. So as authorized now, they are not a very good help on that. That's really my presentation. I'm glad to answer any questions.